Hello, I'm David Thompson, and welcome to Unit 1 Legal Studies. The question I'm often asked is, where do all our laws come from? Ask 20 people in the street, and you're likely to get a strange variety of answers. We're going to screen a short video, which I hope will answer that question for you.
It's an 800-year-old document, written on dried animal skin, in England, on the other side of the world, in a language we no longer use, that most people couldn't read even back then. So why is Magna Carta important to us in Australia today? Because it was the starting point for some of our most important human rights, things it's easy to take for granted. For instance, before Magna Carta, life was pretty cruisy. If you were a king, you could get away with all kinds of things. Forming your own armies, invading other countries whenever you fancied, and taxing people to pay for wars without even asking. Now, there were laws in those days, but some rulers believed they had absolute power and simply ignored them. That changed in 1215, when a group of landowning barons finally had enough of King John's behaviour. They decided the king governed by their consent, not just because he was king. So they got together and forced the king to agree to limit his powers by signing Magna Carta. It was the beginning of fairer rights for the people. The king also agreed he couldn't just add new taxes. Free men had to be represented by a common council to be taxed, which started the evolution of democracy. It also meant the king was no longer top dog, because above him now was the law. Or at least that was the idea. Kings and queens had a lot of trouble getting used to not being in charge. But over the next few hundred years, people power, in the form of Parliament, grew to be much stronger. In its Bill of Rights of 1689, the English Parliament formally decided it was the job of government to represent the people and protect their rights. These ideas came to Australia in English law. We know today if someone is accused of a crime, they have the right to a fair trial, and they must be proven guilty before they can be punished. Before Magna Carta, justice wasn't always applied fairly. Remember old King John? He was pretty good at filling up the prisons. But under Magna Carta, it was no longer up to him to decide whether someone had done wrong. It said, "No free man shall be seized or imprisoned, except by the lawful judgment of his equals or by the law of the land." Now you had to have a reason to lock someone up, and later people decided you also had a right to argue your case in front of a court. But in 1215, no free man didn't mean everyone, because in those days most people weren't free. They were poor peasants who served the lords. It took till the 16, 17 and 1800s before all men were free in Western countries, and most women waited until the 20th century. In 1948, after the atrocities of World War II, the nations of the world created the Universal Declaration of Human Rights. For the first time, the whole world recognised that everyone, it didn't matter who you were, had the right to enjoy freedom of speech, freedom of religion, and freedom from fear and want. It has been described as the international Magna Carta for all mankind. So, this faded old piece of animal skin has played a big part in shaping the democratic society we have in Australia today. But many people around the world are still denied their rights and freedoms. This reminds us human rights shouldn't be taken for granted. And until they are, the long story of human rights and freedoms that began with Magna Carta will continue.
I'm very pleased that you have chosen VCE Legal Studies as part of your Year 11 course, but let me dispel a myth. Many secondary students believe that legal studies is only for those planning to study law at university. That's actually very far from true. Many decades ago, Australian-born Judge Lord Atkin, about whom you'll hear a lot as you go through this course, told students in Birmingham that law should be taught as a Year 12 subject, and these are his words, because a knowledge of the law and its administration should be part of the ordinary equipment of the good and efficient citizen. I think he'd be very pleased that the Victorian secondary curriculum includes legal studies and civics and citizenship, which has a substantial law component, and he'd be very pleased that we are all here today. What I'm going to do now is outline some of the ways in which you can prepare yourselves to do really well in this subject. You might ask the question, what should I be doing now? Well, one of the things I'm going to suggest that you do is get a hold of the VCE Study Design for Legal Studies. Now, you can buy a copy, a bound copy, but you can also download it from the website, from the Victorian Curriculum and Assessment Authority website. Why should you have that? Well, for two reasons. First of all, it tells you exactly what the course contains, and it also sets out precisely what you can be assessed on. If you have that information before you, it will really serve as an excellent guide to what you do over the course of Unit 1 Legal Studies. Now, when you're looking at that study design, you'll notice that each area of the course requires you to consider how the operation of the legal system can be assessed by three criteria. And these three criteria are, I'll go through them one at a time. The first one is fairness. Now, fairness is the first principle of justice. It means impartial and just treatment or behaviour without favouritism and without discrimination. Now, think of COVID vaccinations. Everyone was entitled to a free vaccination, but if the information about the vaccination was only provided in English, many people would not know about it if they only spoke and read another language. The government, fortunately, published information in a wide range of languages, which meant that it was a fair process. It was possible for everyone to find out about it. Now, if someone steals a car or is caught and charged with theft, that person, to be treated fairly, should be able to understand a number of things. They've been charged with stealing a motor vehicle. So what do they need for a fair process? They need to understand the court process. They need to be able to understand the court process, have it explained to them if necessary. They should also, very, very importantly, for a fair outcome, have the opportunity to present their defence. Now, that means having the opportunity to disprove the prosecution case. The second principle is equality. As I said, that is the second principle of justice. Everyone should be treated the same, regardless of their personal characteristics or beliefs, such as age, gender, religion, ethnicity, cultural background, disability, or sexuality. Everyone should be treated before the law. No one should have an advantage or a disadvantage because of a personal attribute or characteristic. There should be no bias or prejudice in the legal process, and the person who decides the case should be absolutely impartial. That's what equality is all about. And then there's access. This is the third principle of justice. People should be able to pursue their case in court. Assistance should be provided for those who otherwise could not afford to pursue their case. That's why we have legal aid. Now, as I've said, these three principles appear throughout the course, and you assess how the legal system stacks up against those three principles. Now, what does Unit 1 contain? Let's have a look at the elements. The first of these is the legal foundation, or legal foundations in the plural. Now, you had a look at that little video a few minutes ago, which I hope you found informative as well as entertaining. Under this first area of study, what you're going to look at is the characteristics of an effective law. What makes a law effective in Victoria and in Australia? What would we say about a law? We say that's an effective law. What are the characteristics that make it effective? The second element that we're going to have a look at under legal foundations is the sources of law, like our little video. Where did the laws come from? You'll be beginning to get some ideas, particularly if you're watching the television news, because you hear about laws being passed and this happens all the time. You'll also have a look at the relationship between courts and Parliament. Hopefully you'll get an opportunity to visit Parliament and the courts during the course of your study of VCE Unit 1, 2, 3 or 4 legal studies. Under legal foundations, you'll also have a look at different types of law. You've probably already thought about criminal law. It's the one that gets in the newspapers a fair bit, but there's also civil law. And you'll also have a quick look at each of those. When I say a quick look, you'll have a study of what criminal law is, the sorts of things that make up the criminal law, and the sorts of things that make up our civil law, the law that deals with relationships between persons and organisations. The second area of study in Unit 1 is the presumption of innocence. Now here, of course, we're touching on criminal law. This is the principle that you're not guilty of a crime until your guilt is proven beyond reasonable doubt. Now let's go back to the young man who's been charged with stealing a car. The prosecutor, in this case, will lead evidence from witnesses who say they saw a skinny man in blue jeans and a red jumper with sandy hair open the car door and drive it away. The police saw a young man of that description a few streets away a couple of hours later, and they arrested him. The car had actually been abandoned at the end of that street. Now, when this matter went to court, the accused, that is the person who's been charged with the crime, called a witness who swore that the young man had been mowing her lawns at the time the motor vehicle had been stolen. She was an independent witness, no connection to him other than the fact that she could swear that he'd been doing that work in her garden at the time of the theft. Now, the magistrate in this case reckoned that there was reasonable doubt and found the young man not guilty. In other words, the prosecution failed to establish that he was guilty, the presumption of innocence. Guilt was not proven, therefore he was found not guilty. You look at a number of crimes throughout the course, so watch the news, read the papers. Some of them are pretty spectacular, some of them are not. But they're all appropriate to consider in relation to what you're studying in Unit 1. The third area of study is civil liability. Civil law aims to protect the rights, as I said before, of individuals, groups, and organisations. Now, you won't remember each of these right now, but what you'll look at are things like negligence. When someone's negligent and causes injury or is alleged to have caused injury to someone else. Defamation, saying something which harms a person's reputation. Nuisance, and that can be things that come onto your property when you don't want them. And trespass, which is when people come onto your property and you don't want them. And you'll have a quick look at the law of contract. But let's look at one of these. Imagine you're a film star and you discover that a number of gossip magazines publish stories about you which you claim are untrue and have cost you your work. In other words, you've been knocked back from film work because of these things that have been said about you. Now you decide to sue the publisher. The court has to decide whether the actions referred to you, you'd be called the plaintiff, the person bringing the action. Were they published? Well, they were there in the magazine, weren't they? Were they untrue? You can show that they were. And did they lower the reputation, your reputation, in the eyes of other people? Now, what the court had to decide on the balance of probabilities. Now, that's a lower standard of proof than beyond reasonable doubt, which is the criminal standard. The court had to decide if the publisher was liable for defamation. And of course, if this sounds suspiciously like the Ribble-Wilson case, that's where I got it from. What else should you be doing as the term gets underway and you start to look at cases and other information that your teacher provides you with? First thing I'm going to suggest is something about case notes. It's very important, if you are dealing with a case in class or in your reading, that you record the information about that case. Now, I think of this old fellow called FIDS. FIDS is a very useful friend when it comes to writing case notes. F stands for facts. Who did what to whom? What happened in the case? You can put that down in a couple of lines. What are the issues? That means, what are the things the court has to look at? What issues does the court have to assess in order to reach a decision? And D, of course, stands for decision. What did the court decide? Who won? And finally, S stands for significance. Why are we looking at this case? What does it tell us? Is it a really good example of the area of law that we're looking at? Might it be that it's significant because the decision in this case changed the law? Perhaps it added a new principle. Perhaps it took away an old principle. Those sorts of things are important to record in your notes. I used to do it on a little card about the size of an envelope. And I found that very useful when I was a law student a long time ago. You might also note that a case is significant if you can use it as an example in a number of different parts of the course. There's no rule that says you can't cite a case example in several different parts of the course, if it's relevant. And some cases you will find are very relevant. So think of facts, issues, decision, and significance when you're looking at cases. Well, that gives you a taste of what Unit 1 Legal Studies is all about. I hope what I've provided today is useful, and I really hope you have fun in legal studies in Year 11 and go on from Unit 1 to the rest of the course. All the best.